Alright, so far in my research about the 48-hour warrant, I have learned a little bit more, and I'm not so sure that they exceeded the warrant exactly in Natchitoches, Louisiana. It doesn't seem like Judge Owsley he seemed to have broken it up, this 48-hour warrant, where I was arrested January 22nd, 2022 at 1 p.m. and he signed a 48-hour warrant demanding that I be taken into custody immediately upon this warrant when I was just sitting in jail. So he held a probable cause hearing, and I've been going back and forth with ChatGPT on that, and it sounds like I don't have to be present for probable cause. He can do it based on police reports and body camera and other evidence, testimony. He could make his 48-hour arrest warrant. And I believe I have the name of the case in my phone for the 48-hour warrant. There is a court case out of California, and they talk about it. Let's see, I got questions there. I've been doing a lot of various research. This would be my last check. It's a habeas corpus is petitioning, initiating, and okay, no, okay, I don't. It was a case that I'd never heard of before. It's 1991 out of California, and somebody versus somebody, and I just ChatGPT dug it out and keeps referring to it in a lot of my questions about how there's a 48-hour window that the Supreme Court decided is the length of time that you could spend in jail without probable cause. Now, Missouri has condensed that to 24 hours time limit for probable cause to bring you before a judge. There is a 24-hour rule, but the U.S. Supreme Court made the standard 48 hours. But yeah, in North Dakota, I sat in jail for like 3 or 4 days a number of years ago, 2020, and there was nothing. There was no charge there, and that would have applied as well. But the judge in Natchitoches, Louisiana, my current case that's been going on since January 2022, I see that the judge immediately, within like 4 hours, wrote the warrant for my arrest. So that isn't exactly going before a judge, because I didn't know he signed that until after I was released 3 days later. So does that really count? I mean, he's allowed to hold probable cause without my presence. It's called ex parte. But then hold me in jail, and he only decided probable cause, that I needed to be arrested. He was aware that I was in jail. He wrote out the 48-hour warrant for my arrest, and then I saw nothing. I heard nothing for 3 days, and then I have to go into a room, and then they forget about me. I had to let them know that I'm in jail. It's been 2 days, and and they just, on that second day, they said they forgot about me, and so they'd have to process me the next day in 3 days. Which, I mean, what's and I question, when you go past that point. I mean, even though Judge Owsley, he viewed the case and he found probable cause, still there was no communication for over 3 days. Okay, and I think there needs to be some kind of communication, and I need to go back and forth with ChatGPT on that. There needs to be some kind of communication between the defendant and the judge within 48 hours, not just simply the judge signing this arrest warrant. And weekends don't even matter. Okay, 48 hours is 48 hours. It doesn't matter weekends. So judges work weekends. If somebody's arrested, the judge has to come in. I mean, in bigger cities, they have night courts. They made a whole TV series about night court just to meet the demands for the number of arrests that occurred and meet the demands of that 48-hour warrant. It could have been that TV series Night Court was inspired, or maybe it was a TV series from the 80s. Either way, it was 91 that the 48 hours was placed. I don't know how long the time limit was before that. It was certainly likely much longer. But I sat in jail for that length of period of time, not hearing anything, not knowing anything. And then I get Layla Sylvester on the phone at 3 days, and she's a district judge, and she just said that I have a bail set at $1,500. And that's a district judge. That's the last I hear from the district judge. For some reason, the district judge got involved because Judge Owsley failed to get involved within 48 hours. So they just maybe put the district judge on the phone instead. Was Judge Owsley really that busy on that day or the day previously? He's a part-time city judge. And I argue that, if I'm going to have a district judge tell me what my bail is, then maybe I should have district judges. Maybe I should be able to request a district judge to also hear my case and be allowed the jury trial, since I was put in jail as a result of the whole matter. I should have a right to a jury trial and was denied that. So I don't understand how they can go back and forth at their own leisure. What gives them what gives the state of Louisiana the right to be able to go back and forth? First Judge Owsley puts out my arrest warrant. Then 3 days later, a district judge tells me I have a $1,500 bail. And then I go back to Judge Owsley again. And it's that mix and match. It's just, once again, people say that the Louisiana court system is screwy, and the people have no say in it. That's why it's so screwy, because everything is exclusive is privilege. They claim a lot of privilege for communication and information, excessive amounts of privilege for information, taking out the input from the defendant. So I'm just evaluating this, and it's weird how they can put out this arrest warrant but have no bail. So the arrest warrant was within hours, and then it took 3 days to hear what kind of bail I was facing. I don't know why Judge Owsley couldn't figure out bail with the arrest warrant. He could just miraculously figure out, read all the information that he was given, whatever that was, police reports mainly, I guess, and then make his conclusion that yes, there's enough probable cause to go forward with the trial, but to not set any bail, and to not even hear, to have a hearing on it. He didn't bother. I didn't see him until 3 weeks later, and I was actually scheduled to talk to him to have my first hearing within like 4 months. In 4 months, they push back the date so far, almost to the point where you forget about it. It pushes back the your speedy right trials, your speedy rights to the speedy trial. And I asked for the next court dates. I had to actually ask. I do that every time. My court date is always scheduled far out, months, 2 or 3 months. And I'm a traveler. I want to have a faster hearing. I want to get this done sooner. I want to rock and roll with this, and so I'm always the one asking for a sooner date. Can I get the evidence sooner? Can I get a sooner hearing dates? I want to get this information out, because it's gotten a lot easier to write motions with ChatGPT. I mean, the new ChatGPT 01, it thinks a lot harder. So to make a request for a good motion to suppress evidence, a motion for discovery of evidence, bill of particulars, write me out a good bill of particulars. It's you have to input all the fine detail as specific as possible, so that it can do its best work. Because I've been making some questions for the sheriff departments that I've been visiting, and I'm constantly refining them, because ChatGPT isn't quite getting where ChatGPT is asking good questions, but they're a little too hard for the sheriff's department to ask. So I've had to refine them, like asking who all the tow truck companies are. Do you keep a list? And so far, out of the 2 sheriff departments that I've asked, they've said they don't keep lists. They just kind of choose the dispatch chooses the nearest tow truck company. So that's making me refine my questions, because I think I'm going to hear that more and more if I keep asking that same silly question. So I'm going to change my question to asking, since it's so random that the sheriff's department seems to be calling the tow truck, because I'm facing extradition issues from another state, because I don't believe I'll make it October 17th to my hearing in Natchitoches. I'm 1,000 miles away, and I think my car might get towed if I get extradition problems. So I want to learn more about that. And one question now, after stopping at a couple of sheriff's departments I have, is does the sheriff's department, or will they, check this tow truck driver's license and insurance? Okay, I think that would be a better question to ask, just to see what they say. Maybe it can elicit another idea in some way. But I can't be asking, do you have a list of the tow truck drivers? Because they're just like, oh, the dispatcher keeps it. Oh, we call random tow trucks. The state is in charge of it, so we just get the closest one. All right. Well, I'm thinking maybe think more on the scene, because that's how they operate. That's more what's happening on the scene. Do you check the tow truck driver's license and insurance? Is there a special insurance? Is there a special? I mean, they're not going to be able to. It sounds like they're not going to be able to say if they have a special agreement. But I mean, is there a special insurance at least? Do you check that to make sure that to make sure that tow truck drivers qualified to take my car? I'd like to know that. But that's with that, because I'm facing another arrest. Pretty much, I guess I could say I was arrested twice. Once in the library, then again after my trial, and now I'm facing a third arrest, all for failure to ID. So, and then it's going to be charges compounding on top of each other. Man, I've attended so many hearings. It's like, it's number 9 that's going to get me. It's looking like hearing number 9 is going to be the one that's going to get me a failure to appear. That's all they need to do, is just keep piling on hearing on top of hearing until you finally miss one, and then they could just throw you in jail for it'd be considered contempt of court, and the judge can put you in for 6 months. That would just be incredible. and this is under Judge Brian Barber. So I'm learning this initial stage is screwy. There seems to be some compliance with the 48-hour warrant, but not enough where there's communication between the defendants and the court. Okay, it's just kind of a one-way. The court just says I can stay in. Judge Owsley's taking it upon himself to approve that I stay in jail, but there's no communication with me, the inmate, the defendant. I was just simply told I was forgotten. So being told I'm forgotten in jail does not sound like compliance with the 48-hour warrant. I think there needs to be, and maybe it was argued in that court case. Maybe I need to ask ChatGPT. ChatGPT, was there any decision, any talk by the Supreme Court about whether there needs to be communication between the court and the defendants? Because the way Louisiana seems to be doing it is they're just writing the paperwork, and they made the communication, but it's like they communicated, but it's not received. They sent out the message, but there's just no receiving by the defendant. I didn't get any information. I was left in the dark and told that they forgot about me, which caused me to stay an extra day. And there seems to be a disconnect between Louisiana's interpretation with this law, which maybe isn't discussed in enough detail. Louisiana's using the cloudy areas of this law, and working their own way in the gray area. But I mean, this is due process. This is a due process problem, regardless. So this is something that I'm in the process of trying to learn more about, and I'm just talking about it. So that's it.